Alright, so now let's go to trial. Start off with opening statements. This is basically the attorney's first shot at trying to convince the jury that what they have to say is correct. Sets forth the facts they are expected to prove during the trial. Well, certainly, if I'm going to represent He-Man, right here, I'm going to say, hey, jury, this is a story about He-Man, who was beaten up by Superman. Superman intentionally hit He-Man with the intent to cause harm. Okay? Opening statements. Each lawyer will have the opportunity to give a brief version of the facts and the supporting evidence that will be used during trial. Right? At trial, we use the rules of evidence. Everybody always asks me, how are you going to prove things? How are you going to do this? How are you going to do that? Well, it's evidence. You have to follow the rules on how to present evidence. It's a series of rules that has been created by the courts to ensure that evidence presented during the trial is fair. That's what we're trying to do, is be fair. Alright? First off, all evidence has to be relevant. Okay? Relevant evidence is evidence that tends to prove or disprove a fact in question or to establish the degree of possibility of a fact or action. So, what would be relevant to the He-Man Superman battery incident? Do you think that it's relevant that it was, 3 o'clock in the afternoon? Probably not. Okay? Do you think it's relevant that they're both superheroes? Well, yeah. Do you think it's relevant that Superman balled up his fist trying to hit He-Man? Look. Very clearly. See that? You see that? Superman's fist is all balled up. Alright? I think that's relevant. Alright? Hearsay evidence. Hearsay is any testimony given in court about a statement made by someone else who was not under oath at the time of the statement. This is basically saying, well, I heard my mama say that your grandma said that you were fat. What? It's ridiculous. It's hearsay. It's inadmissible. Alright? Examination of a witness. Alright? You have direct examination. And this is when the attorney first gets to examine his witness. Okay? It's the initial questioning. Please tell us what happened. Did this happen? What was going on? Cross-examination, on the other hand, is when the opposing counsel gets to get up and ask questions. Generally, it's along the lines of, isn't it true that this happened? Or isn't it true that you have a stake in this? Or isn't it true? Those are what we call leading questions. And those are questions that tend to have the answer built into the question. Can't do that on direct, but you may do it on cross. Alright, potential motions and judgments. Motion for a judgment is a matter of law, or motion for a directed verdict. This looks at the evidence in the light most favorable to the plaintiff and grants the motion only if there is insufficient evidence to raise an issue of fact. So this is done generally after the plaintiff presents their arguments. Hey judge, even after everything the plaintiff says, they still haven't proved their case in chief. They still haven't proved that Superman actually hit He-Man. As such, it should just be dismissed. Well, after that, the defendant gets to present evidence. Generally, rebuttal. After the defendant's attorney has finished presenting evidence, the plaintiff's attorney may present evidence for rebuttal. Alright? So, you always have an opportunity to cross-examine, to present other information. Rejoinder, after the rebuttal, can be done to refute that evidence. Wow, just never stops. But anyway, after both sides, plaintiff and defendant, present their case in chief, we go to closing arguments. Okay? Well, the closing arguments, basically this is each attorney summarizes the facts of what happened at trial, everything that was admitted into the record. And it's their last opportunity to tell the jury, hey, this is what's happened, this is why you should find for my client, or you should find the defendant innocent or guilty or not guilty. You have the jury instructions, which comes from the judge, and it says, hey, this is what you're supposed to decide. And the jury goes into a deliberation room and they return a verdict. And that's where they specify what they found out factually. Alright. So after that all happens, the judge reads the verdict and everything's done. Then we have the post-trial motions. You do a motion for a new trial. Alright? This will be granted if the judge is convinced, after looking at all the evidence, the jury was actually in error, but does not feel it is appropriate to grant judgment for the other side. You also have a motion for judgment notwithstanding the verdict, or JNOV. And this is basically granted only if the jury's verdict was unreasonable and erroneous. Okay, so that's trial. After trial, you can file for an appeal. Alright? You generally do this by writing a brief. And that's a formal legal document outlining the facts and issues of the case, the judge's ruling or jury's finding that should be reversed or modified, the applicable law, and the arguments. Right? This is why we object. You object to things so that you can reserve the right to appeal them. Okay? You have appellate review. Right? You can see the option on page 56. Okay? Enforcing the judgment. All right. So after we go through to trial and all the appeals, we have a judgment. Well, how are we going to collect the money? Right? Well, we can request for the court's assistance. We do a writ of execution. It's an order directing the sheriff to seize and sell the defendant's non-exempt assets or property, and the proceeds from those sales, sale of those items, will go to pay for the judgment. Okay. And here comes my son.